Good morning, everyone. We're here to consider Senate Bill 157 by Senator Seth Hart from Midland. I know where Midland is. I have been to Midland, starting back, no, not in Texas, starting in 1992. Remember that? I remember.
You ready? I'm ready.
What we're going to do, Mr. Chairman, is we're going to have this in the I don't have a witness list yet. We'll have this in the context of a hearing only at this point. My sense is that we'll have we'll probably have a fair amount of feedback and input on it. I don't think we're going to meet tomorrow morning. My assumption is we're going to go in at 9. If that's the case, then the full committee will not meet. If full committee does meet at 10 o'clock tomorrow, if the House goes in at 10, the full committee will meet at 9. We'll continue the hearing and take testimony at that point. I just don't know what the schedule is at this point, and then we'll continue it first part of next week, and we'll go until we're done, and then we'll work in the context of a substitute and move on from there. Let me just tell you, I'm gonna in about 5 minutes. I'm gonna just go upstairs to rules, to House rules, and ask for a Senate bill.
Okay, thank you, sir.
I'm gonna go to House rules and ask for a Senate bill. After I incur the wrath of Khan for doing so, I will come back here.
Be sure and tell Khan that I passed Representative Harbin's bill yesterday in the Senate. Not only did I move it, I moved it through my rules.
I will use whatever tools at my disposal, credible and otherwise, to advance a particular Senate bill at this point. It's good legislation.
I think we all have some real good legislation out there, and we need to help one another.
But I
applaud you as always.
I'm looking forward to the really
thank you very much.
Terrible looks that I'm going to get in a little bit, but that's part of the process. I appreciate you bringing the bill to us. I think the best thing that could happen, for purposes of our understanding, members will come in the next few minutes. Sure. Please know. I sense this is a fixed bill,
right?
As I call it, it's a fixed bill.
That's exactly right.
And what would be most productive, I think, beyond whatever opening statement you're certainly more than welcome to make, Senator, is tell us about the fixes that are in it and why. We probably need not go into a long history of the Supreme Court decisions, but in general there are specific fixes in here. If you can give us some context on what happened and why they're in there, right, and the validity of the fixes themselves, that would be fine. I will disappear in 5 minutes, be right back. Right. I'll turn it over to someone. You'll probably still be going, and we'll march on from there.
Thank you, Mr. Chairman.
Thank you, sir.
I will start off by giving a little brief history of this bill. As you're all aware, your majority leader, I think, brought forth House Bill 1059, which was our sexual predator bill 3-4 years ago. At the time that Representative King brought this forth, we have a problem of sexual predation in Georgia, and there's something that we absolutely have to do. I applaud his efforts. We've certainly put attention to this problem, but by the same token, we shortly realized that there were some constitutional hurdles that had not been met. We had reached very broad and very expandingly, and we quickly found out the courts narrowed it down and has chopped a goodly number of pieces of 159, declaring portions of it unconstitutional. As I looked at this, and this past summer I was meeting with the Lieutenant Governor, and I brought it to his attention. I said, we've got a real problem here because we've got this thing, and we're losing sections of the law, and as they're declared unconstitutionally, we effectively don't have any law. And I said that I would carry this skunk and try to make this skunk into a perfumed kitty, and exactly that's what has been my goal in this process. I assembled, and we brought in folks from the Attorney General's office. We brought in folks from every avenue that we could get. We included and asked Ms. Fox and Representative Keene's staff to be a part of the process, and we provide. I don't think they took that much of an active role in the process, but they did. We provided them every step of the way with what we were doing. With that said, the bill, while it's got a number of sections, really has two processes that are at work here. The first process was to address the constitutional challenges that we have. I have Miss Mary Beth Westmoreland. Yeah, and that's a mouthful at this time in the morning. From the Attorney General's office, who is here today and can address and respond to all the questions about that. And the second thing is we heard from law enforcement and our district attorneys, and hearing from them, what we tried to do is address the functioning problems that they were encountering, because what we want to do is we want to concentrate our assets in a manner that we absolutely identify the dangerous predator, and we isolate that person to the absolute maximum extent that we can do so under the law. And another aspect of it is that there were some things when we reached out too far. I'll give you an example. There was a criminal case where a young man robbed a convenience store and forced a 14-year-old onto the floor. Well, the crime was an armed robbery. But because he forced the 14-year-old on the floor, he was treated as a sexual predator and had to register as a sexual predator and have all the sexual predation things. Didn't have anything to do with sex. It had to do with armed robbery. And that obviously ran into conflict with the court, and these are the types of institutions and such situations that we're trying to address. But with that said, Mary Beth, you want to come up and we can answer questions. That's kind of an oversight of how we are and what we're trying to do. But I'd be happy to answer any questions. We have folks here from the sheriffs and law enforcement community who also are available to speak if you have some technical questions. Again, the technical questions were to try to make the system work better.
Let me ask you, and I think the committee might benefit, again, I'm just going to disappear for a few minutes, come right back, is to walk us through those specific fixes, the basis for the action, what the fix is, and why. I think it would be helpful to members of the committee. I think it'll promote questions, which is good. It'll help us work through it on a what I'll call a fix by fix basis. And I'll be right back. Thank you.
All right, Mary Beth, you want to start?
Mr. Chairman and members of the committee, what I can do is walk through. And again, this is not. We've been trying to work with whoever's asked us to provide input. Parts of this bill, we have had some work on parts of it, I think, come from some of the sheriff's input. Maybe seem familiar with some bills from last year. What I can do is walk through and tell you what some of these parts are doing, or the attempt, or the effort. There we go. And just walking through section by section, and if you will look, one of the issues that is attempting to be addressed is the Sex Offender Registration Review Board, the backlog it has, the difficulty it's having keeping up with the cases. How to best do that, there's one way that's in this bill, and that's part of what this is. There's another, in relation to that, when that board was given a huge increase in its workload by House Bill 1059, which it became a very small board doing very little on referral from trial courts to a huge board looking at all sex offenders. The issue was, well, how do we really do this? And it became apparent to all those involved that there needed to be some processes put into place to deal with appeals from the classifications of the predators. There were no time limits put in for those appeals. There was no clear process set up. So some of that is what this bill is also designed to do. If you look at Section 1 of the bill, this would make appeals from the Sex Offender Registration Review Board a discretionary appeal. Currently, the statute is silent on how those appeals are handled. Section 2 is an option for trying to deal with the backlogs of the Sex Offender Review Board, which would remove the classification process back to the sentencing court. Again, that's an option on how to try to deal with some of their backlog.
And when we do that, we will assign 3 levels of risk. Level 1 is the lowest level. Level 2 is a mid-level, and the final is the sexually dangerous predator. And as we make that qualification, it will give the trial court the authority to make those assessments and determination. And they can determine both sentencing, and they can determine where they want to go in regards to that. Okay.
This would obviously be something that would have to be prospective only as to people being sentenced after the effective date of the act if it were to be done this way. The trial judge would have the same information that the board gets now, The judges used to make the final determination on this before 2006. If you look at Section 3, this is where we start looking at some of the, and I don't like to use the word fixes, but to address some of the court cases and some of the issues that are out there. There's a case called Santos versus State that addressed the issue of homelessness and found the fact that our statute did not give sufficient notice to homeless people what they could do or had to do in order to comply with the registration provisions. That's what paragraph 1, lines 68 through 73 is addressed to the homeless provision, and it is addressed to Santos. If you look at the paragraph 6, I believe is from, and I don't want to speak for the sheriff, so I won't. I think that's dealing with some of their concerns. It also addresses, may address some of the homeless issues. If you look at beginning on line 79, there are two sections there on kidnapping and false imprisonment. There is a case currently pending, Rayner versus Purdue, challenging, and it's exactly what Senator Harp said, the fact that we've got cases where people are not really convicted of sex offenses, but they're being put on the registry because it's, right now, if kidnapping of a minor or false imprisonment of a minor is a sex offense. And this would make it more clear that what you're looking at is offenses that actually do have some impact on conduct directed to a minor, more than simply an armed robbery where somebody is put off into a storage room and it really doesn't have anything to do with anything other than the age of the victim. There are two provisions because of the way the statute is drawn. These are dealing with two sets of cases, a pre-certain date and a post-certain date. So both 79 through 85 deals with what is currently A9A, and 86 through 92 deals with A9B. They do the same thing. Going down to line 93, this is essentially, we've heard a lot about Romeo and Juliet exceptions. This is somewhat of one. We currently have had one judge declare a registration requirement void because currently people who are misdemeanants don't have to register. If there were misdemeanants before a certain date, they do have to register. Just when the statute changed, it didn't take folks off who are misdemeanants. All the new folks are. There have been some legal challenges to the fact, well, you know, because of the date of my conviction, I still just had a 12-month sentence. You know, 2 days later, I wouldn't have to register 2 days before I do. This provision would treat basically all misdemeanants the same way. Is what that would take care of. If you look at the top, well, it's on line 99. The email addresses, usernames, and passwords provision. There's currently a lawsuit pending in the Northern District of Georgia challenging the username and password provision. The federal district judge has asked Emmett Bondurant to come in and represent the plaintiff in that case. It's on hold to see what happens. The big challenge is to user passwords. I think this would simply remove the requirement of providing user passwords. There is a case, I believe, out of Utah that has addressed that. I don't know of another state that provides for a requirement of providing passwords. IDs, usernames and email addresses, yes. Passwords, we haven't found somebody else who has that requirement. If you move on down, beginning on lines 101, this is again a part of the attempt to address some of the concerns with the Sex Offender Review Board. You'll see several provisions in here referring to what would be a new 1710.6.4, which would be the provision for the Sex Offender Review Board. Section 4, I believe, is one of the pieces coming from the sheriffs. I haven't had anything to do with that provision. It doesn't relate to pending litigation that I know of. And the same with Section 5. I would note on Section 5, some of those requirements would be part of what is required if we were to try to comply with the Federal Adam Walsh Act.
Could you comment just a second about Adam Walsh? So
The Federal Adam Walsh Act, and there's a second version of it actually as well, is the federal sex offender registry law that also is an attempt to get a national registry, to get the states to brought into it. What it does is put a stick. The federal government cannot force us to comply with their rules, but they can say we're going to withhold certain burn grant funds if you don't. Currently, no state has managed to comply. The initial deadline is 2009. Then most states are asking for extensions or have been rejected and are trying again. There's a lot of talk about whether there's going to be some change in those requirements and what might happen. Part of it is an effort to get some sort of national communication, and some of it is some of the federal requirements are more stringent than ours, but not many. I mean, most of them we're pretty much we're in line with on some of it. There's been a working group to try to look at how we would come into compliance if the policy decision were made to do so. If you look at Section 6, Section 6 is derived from the case of Sharma versus State, which is a Court of Appeals case. Sharma dealt with the fact that we had somebody moving in from another state who was required to register in another state because the court went behind the crime and looked to see that it didn't fit under some of Georgia's sex offense crimes. This would say if you're registered in another state, you register when you come to Georgia. If you're registered with the federal government, you register in Georgia. Not going behind and trying to compare an Alabama crime to a Georgia crime to see where they fit. If you look again at Section 7, some of this is dealing with the issue of the homelessness problem and the problem of how to deal with registration of people who are homeless. And there may be folks who can address the concerns about that better than I can, but right now we don't have a way to do it because Georgia Supreme Court has said our way doesn't work. It's not valid.
Which means we don't have any.
Yeah,
Okay.
you have no registration for homeless people at this point in time.
And that might be where the really dangerous predators are located, and that's what's scary. Okay.
I'd like to just move on. Like I said, some of the 8, 9, and 10 are more, I don't know if you want to call them procedural matters. Section 11, on lines 251 and 252, the striking, Georgia Supreme Court in Bradshaw versus State found the provision that required a life sentence for a second failure to comply with the registration requirement to be unconstitutional. So currently you can't do that anyway. One way to solve that is simply strike it or at least do something different with it. Let's see. Section 12, the first part again deals with the issue of handling the Sex Offender Registration Review Board cases. If you look again down on lines 268, this is dealing with people who come in from out of state and how the board handles those cases. Part of what this section does as well, as I said initially, the current process for dealing with how these cases are reviewed by the board and how they are appealed. We have already had one court find a predator determination to be unconstitutional because of a failure to provide full notice and an opportunity to present information. So some of this is an effort to help provide that process, to allow for notifying an offender. If you look over on line 296, a notification by the board to the offender of the determination, sending the classification. This removes a lot of the current procedure but puts in something that actually is a better way to try to get notice to the offenders that you have been classified as a predator. Here's how much time you have to come back to the board and challenge that. Here's your opportunity to present more information to the board. Puts in a time frame for filing then in the court. If you, again, want to challenge the board's determination, if you look on, starting on lines 336, 335, this is where the petition for judicial review of the determination as a predator, or level 2 for that matter, how that could be challenged, puts in time limits for notification. Currently, there's just no time limit. The predator can make that challenge anytime. This puts a time limit in, gives them some rights, but also gives the state the opportunity to have a date certain.
Having it open-ended as it presently exists gives the opportunity to someone, the witnesses are dispersed, possibly even evidence is destroyed or something like that, putting a day certain on this says you have a right to have this process occur, but you have to do it in a certain time. And we do that so that we don't end up 5 years down the road and all the people have gone to the four corners and somebody files a habeas or some other methodology of relief, and what we're trying to do is shut that door.
If you look also on line 340, this is a venue provision. Currently, the current law has these challenges back in the trial court with the determinations not being made in the trial court. What we've had happen is, I'll give you an example. We've had 2 cases in Chatham County, one of which has had at least, I believe, 3 hearings. Somebody from our office has had to go every time. Somebody from the board has had to go every time. People are spending a lot of time traveling around the state. We're just getting started with challenges to these cases. This would put venue where in the county where the board is located. The same way you sue the parole board right now. If you're going to sue the parole board, you sue them in Fulton County. That's where the board is. That's where their resources are, where they've made the determination. It's an effort to keep the board from being off on the road all the time and kind of consolidate these in one locale. And again, the rest of that paragraph is dealing with burdens of proof, time for appealing, and so forth. The next section that relates to, it's somewhat of a case-specific section, Section 13. The current registration statute deals, the residency and employment restrictions have added a provision for volunteers so that the employment restrictions apply to people who volunteer at schools, daycares, and so forth. The statute doesn't have a definition of what volunteer means, and the fact the code doesn't have a definition of volunteer. That's part of the class action lawsuit pending in the Northern District of Georgia. One of the main big challenges is to that lack of a definition. This is an attempt to put a definition of volunteer in. One of the issues deals with challenges to people being able to volunteer in churches, for example, and what does volunteer mean. So this is an effort to try to put a definition in to give some clarity to that provision. And then I believe Section 14 came from a bill that was in the Senate last year, and I didn't have anything to do with the drafting of that. I think it's a method for getting people off of the registry under certain circumstances.
And what we're primarily dealing with is people that are at end of life, and we're trying to be able to allow them to be in a nursing home or someplace like that without having to be literally put out on the street. And while I'm not sympathetic to these people, the other side of that is that I can see the process of rolling somebody out in the bed, out on their deathbed, out into the street because they committed a sexual predation act. Even though, obviously, if you look at the qualifications of this, they're not going to be they're not a predator any longer because they are near end of life situations. And you notice it's seriously physically incapacitated, totally and permanently disabled in regards to the term, and residing in a hospice, skilled nursing home, residential for the elderly, or nursing home. I think we're trying to do that phase of it. Because right now, they literally couldn't stay there.
There's some other parts of the bill that, again, have not been parts that we have been involved in that others might can speak to. I think some of the sheriffs probably have some concerns about some of the notification provisions they're dealing with.
We do have a couple questions. Representative Benefield.
Thank you. And first, I just want to thank Senator Hart for bringing this bill. Like you said, it is kind of a skunk as far as it's not a very politically popular issue, but it's important. And I want to thank Mary Beth Westmoreland and the Attorney General's office for the good work you've done. I just want to make one comment that when the House Bill 1059 first came through, I know myself and others who opposed the measure, not because we didn't want to clamp down on sexual predators and sexual offenders, but we had a lot of the concerns that have been addressed in this bill. And frankly said, I know specifically with regard to the homeless provisions, this is unconstitutional and will be struck down. And it's just unfortunate that we had to pay taxpayer dollars on litigation to strike this down when it was pretty clear, I think, from the outset that there were constitutional serious constitutional problems with the bill as it had been originally drafted, and I appreciate you addressing that. I just have.
I'd like to comment that
Yeah.
We have not been about the process of saying nanny do.
And I'm not trying to, but it's frustrating when, frankly, I think these concerns have been there and were raised, but I'm grateful that they're being addressed. But I have a very quick technical question, then I have a larger question. My quick technical question is, are the offices of the board located in Fulton County? I'm just curious what county would have
They're
venue.
in Fulton County now.
Okay.
They're administratively attached to the Department of Human Resources currently.
Okay, and then my larger question is, you've addressed a lot of litigation. Some of it is active and pending. So my question for you, Ms. Westmoreland, is how is that litigation impacted by this bill, by this bill's hopeful pass? If this bill is enacted into law, would that diffuse the litigation that's currently pending?
And I'm always reluctant to comment on pending litigation, to say too much. Could it diffuse some of the litigation? Yes, it could. And I think several of these measures address cases that have already been decided. The ones we've looked, Sharma, Santos, Bradshaw. The case on the email password is pending. It's on hold. Everybody's just sort of waiting to see what happens. The volunteer provision is in the class action lawsuit. I can't tell you that's going to make that case go away. There are other issues in it, but it certainly would. I think it would impact the case at some point. Yes.
Thank you.
Representative Knox.
On the issue of the review of those classifications, I don't really remember the discussion about the classification of those different types of sexual offenders, and that when we did that bill, does anybody else recall anything about that?
Mm-hmm.
Pardon me?
The homeless issue is what I recall.
Yeah. Is the court going to? What I'm concerned about is having the expertise to decide who is a sexual predator, because that's really, even when we did this bill originally, that was the primary focus of it, was to find sexual predators, people that have committed the offense, and there's a high probability or a good probability that they're going to be a repeat offender. I think there was testimony about that, and there was sufficient evidence. I think there's sufficient evidence that there is an individual like that. There is an individual that's a sexual predator, and they're going to continue to offend. Some of the things that we covered in the bill are not actually helpful in trying to identify and get those folks. That's why I'm asking about this. The classifications. What are the requirements for the classifications, and who decided who should be in what classification? That's one. And two is the court absolutely the one to decide whether or not a person's a sexual predator, or should that be done by somebody who has the expertise to do it? And so is the intent of the bill to have the court identify at least what they believe based on whatever criteria they're given to be, and then pass that back to the board and let them say, yeah, that's in fact who this is?
Well, I think what we're trying to do is do put that in the trial court, because remember, the trial court's where all the facts about the case are going to be developed, and then that evidence is in front of the trial judge. The trial judge heard this. Truly, what I envision is that we probably would have a bifurcated guilt or innocence case, part of the case, and then you'd have the sentencing phase, and the trial judge can call upon resources that they have to develop the threat for predation by these individuals, and would allow that sort of process to happen in the very similar to what they do in the federal courts. If you know, they'll do a pre-sentencing report and have call upon the assets that they have within their community to help them develop that process. But the key thing is you're going to have the person who's heard this horrendous case making that decision. And if anything, I think that weighs more heavily against the accused, because the trial judge, the jury may have been, certainly the jury would probably have been the determinative factor of guilt or innocence, but the trial judge in the sentencing phase has to have these resources, have to look at these sort of things. But that gives that family, the victim, whomever, the protection of having somebody who's heard all the horrible details that's going on will make that decision. But he then has the resources that are available in the statute, which is the sexual polygraph, other evidence, other expert evidence is called upon when he makes his determination of those things. The idea being, though, is to keep it locally so that the determiner of the facts, who's heard the facts certainly, will be the one best able to make that predation decision.
Then, after the court does that, then is it up to what's the role of the board then? Do they have anything to say about whether that's a correct classification or not, or what will be their role in this after under this scenario? I'm not arguing for it one way or the other. I'm just
it would obviously diminish their role, but they're pretty well overwhelmed, is what we're told. Is that correct, Mary Beth?
And I mean, I think the board could speak for itself, but where we're sitting right now is the board's overwhelmed. They're behind. They're backlogged. I mean, part of that is a lack of resources. It's nothing against the board. It's just the sheer volume of the cases they've got to deal with. One way to try to address that is shift that function off the board and back to the trial courts. Whether that's the best policy way to do it is a different issue. The contemplation, I think, the way this is drafted is to get the trial court with the same kind of information the board has. It provides for risk assessment from the Department of Corrections, provides something like a pre-sentence report that the trial courts get now before sentencing, and so that decision is made back at the trial courts. The board's going to have to keep functioning for a long time to deal with current cases in the pipeline, people coming in from out of state and that sort of thing. Before 1059, the board was a recommending body. They only looked at cases the trial court chose to send to them and made a recommendation back. Once 1059 passed, they became the body, and it all funneled to them, and it didn't go back to the trial court at all except for an appeal.
and so all the appeals will be heard by the Superior Court of Fulton County then?
Yes.
Is that what I'm understanding?
Yes.
Do they have the capacity to be able to do that? I suspect you might have more than one or two appeals on these cases.
I honestly don't know. The cases that we're seeing appealed right now are the predators, and that's a small percentage of the cases reviewed by the board. I don't have the numbers in front of me because they're the ones that have an impact. I mean, if you're level 1, there's nothing to appeal. If you're level 2, there's really nothing, not a particular need. It's the predators who will be appealing. The board members could give you a better idea of how many cases that is currently. It's going to grow, but I don't know if they have the resources to handle it. I think it's just a matter of trying to help get this funneled into one place so that we don't have, every time we have an appeal, an evaluator has to go out to testify about what happens. We have concerns about all the board members being subpoenaed to go to wherever. And that's work they're not getting done. When they're out traveling around the state doing appeals, they're not getting the work of the board done. And so that's part of the effort, too.
Are the classifications, are the criteria for these classifications, are they established by someone currently? I mean, is that a set of criteria that's established somehow by someone somewhere?
It's not in the code. It's not in the statute. The board
Right.
has its own rules and regulations, and they use certain testing instruments to make
And
that
they're
decision.
going to give those to the court. The court would have to use the ones that the board uses.
I envision that, Tom. Yeah, I think that's exactly what
I think they're going to do that. I'd like for us to be sure we get that straightened out, so we don't have that have that discussion afterwards. We might need to. I'm not saying we do. I'm just saying we ought to consider whether or not we need to address that in the legislation. Be sure we don't have conflict going on back and forth about who's going to do it and when and on what.
As inclusive as we have been, there's a certain limit of how far you
Yeah,
can
I understand.
go with it.
But this is we spent a lot of time on this the last time we did it, and when we fix it, we need to make sure we do the best job that we can, because if obviously there's a lot of legislation over, and I just want to be sure we get at the folks we want to get at, and that we have a process that's really going to accomplish the protections that we've been looking for. And I appreciate you bringing this bill. This is something we really need to do, and I appreciate you bringing the bill. And I'm not criticizing the bill at all. I want to be sure at least have a full discussion of those things.
Thank you. Thank you very much, Representative Knox.
Representative Everson.
Thank you, Mr. Chairman. Senator, Mary Beth, thank you all so much for this. Chairman Knox basically covered some concerns I had. A level 1 risk assessment classification, level 2 risk assessment. Can you expand on the difference between the two?
Mary Beth.
There's no definition in the code. There hasn't been. I mean, that's not new.
That's right. Okay.
That's and as far as treatment, the predators are the only ones who are actually treated differently. There are provisions in the code for, I believe, lifetime monitoring for the predators, but there's no statutory delineation between those.
Okay, thank you. Also, line 49, I think the risk assessment profile of the offender to be completed by the Department of Corrections. Can you just briefly walk me through that process? I'm not an attorney and I'm venturing into an area that it's just
and
that
honestly,
process itself.
And honestly, I'm not familiar with the Department of Corrections process. I know they do have some risk assessments that they do, and so that's not something that I'm familiar with. They might be better able to provide you with that information.
Okay, thank you. Section 3, the risk assessment
Before
profile.
we leave that, I wanted to let you know we're going to try to get somebody from the Department of Corrections to let you to hear from that so they can respond to that question.
Okay, thank you, Senator. One last question, Mr. Chairman. Section 3, line 75. I want to make sure. Child care facility means all public and private pre-kindergarten facilities, daycare. Is this to include houses of faith, worship centers?
Where are we now?
Section 3, line 75, 6, subsection 6 here.
Well, again, if you have a certain number of children, houses of faith have to be registered with the state. I mean, you picked up everything. What we're talking about is a mom and pop operation where they have half a dozen kids. They don't register. They don't do anything, and nobody knows. A lot of times, people don't even know they exist. You may have, a mother on the block who takes in 3 or 4 children for neighbors and runs this thing in that methodology. We don't know. The sheriffs would not know where they are or anything else because they have no way of letting people in authority who administer this law know that they even exist. And that's what we're looking out, is to try to, if you have a concern, you better register yourself so that you can provide protections for you. But unfortunately, and that's one of the problems our sheriffs have had is they don't know where these places are. They don't know that people are doing this kind of stuff, and there's really no methodology right now to be able to do that, to determine that. Okay. Houses of faith, no. I mean, if they're a large enough program, they're going to be registered. Yeah, they're going to register.
All right, thank you. Thank you, Mr. Chair.
Representative Collins.
Thank you, Chair. The question, I want to go back to basically going back on the Section 2, and I think it's going to get a lot of questions at this point. And I appreciate maybe that you were saying that the level 1 risk assessment, level 2 risk assessment at this point have no statutory definition. What are we using to do that with? And I understand if there's no statutory, there's got to be something out there, otherwise it's purely subjective.
Currently, that's being done by the board itself. They enacted their own rules and regulations, and I don't have it with me, but they use risk assessment tools that are used by professionals in the field to make a determination, and really the primary determination is whether the predator is the high risk of reoffending is the key. Those terms have been what's been used in the statute and have never been statutorily defined, actually.
Okay. Then I'll take maybe a step further. Level 1, if I'm a level 1 risk assessment, what will I be allowed to do or not do if I was a level 1 as opposed to a level 2?
There really isn't a difference between level 1 and level 2.
Then why do we have it?
Good question. I don't know.
Thank you.
That's what they've used. The board has traditionally used, and within their rulemaking authority, that's how they have done and how they have obviously. Right. That's the least. That's the person has committed a crime and is the least fearful of being a repetitive
Okay.
person.
Well, I guess, and I understand that, and I appreciate saying this is some good stuff to start talking about. But my question is, again, we're putting something in here that inherently has no distinguishable difference, and are we perpetuating something that maybe could just be you're either a level 1 or you're the low risk or you're the predator. I mean, because if it's level 1 and there was a difference between the two, then maybe I could understand it a little better.
What we're doing is deferring to the board and their rule-making authority. And the board is making by their rules. They are the one that are distinguishing the level 1, 2, and dangerous sexual predator.
Okay, I understand that. So let me just take it then a step further, Mr. Chairman. Sure. If we do have this broken up into level 1, level 2, then that tells me that at some point in time there may be a rule procedure that you're going to treat level 1 and level 2 differently. And if that is true, then I would love to hear maybe at a later time what their possibilities are. By leaving it in here, I believe you're opening up the possibility by rulemaking, not by anything else, to treat people differently than maybe the statute intended. And that's just a first question of concern.
Well, I think that's exactly what our goal was, is to defer to those administrative agencies through their rulemaking authority. They would make that distinction.
Okay.
And they would outline the testing criteria that they're going to use. They would outline the various things that they look for, and that would be kind of a checkoff list of what they're looking for when they make those determinations.
Okay. One final question.
Sure.
Is the page 3, line 73. I understand this issue is the homeless issue, and I understand the constitutionality and non-constitutionality. However, I am concerned about just a question. The term shall include, and we list all these places. And then we come to this last one. It says, and parked vehicles. Given the connectivity to the reporting times with the sheriff's department, parked vehicles may be parked one place one night. If they can't find another place, they have to park another night. And I understand people will sleep in the parked vehicles. I'm concerned, though, if we include that, or how we can include that, and then there be do they have to ride by the sheriff's office on the way by and say, oh, I'm parking over here tonight? Is that what we're saying?
Yeah.
Is that what we're
absolutely.
saying? Okay.
That's absolutely correct.
Okay. And that's curious on how you're going to do it.
Yeah.
All right,
yeah. I mean, that's the sort of thing they're going to have to report where they are.
And that's good. That's what I need.
Okay.
Representative Ramsey.
Thank you, Mr. Chairman. I guess this is just more of a technical question. In Section 12, line 296, if we're creating this new requirement that the board notify the sex offender by first-class mail of its risk assessment determination, and maybe this is somewhere else I'm going to miss it. On the face, are we still kind of creating a problem? How are we going to get that notice again to the homeless person?
Remember, the homeless person has to tell us where they are.
Okay. But I mean, on the face of it, we have to give every sex offender by first-class mail the determination of the risk assessment, and if they're in a parked car or if they're in a homeless shelter, how are we going to deliver it via first-class mail?
If they're in that parked car, it goes to the sheriff's office. And the sheriff's office, when they come and say, I'm in my parked car and the car is across the street from the Capitol, they stick it in his hand right there.
Should we clarify that? I mean, because it says pretty. I mean, the current scheme just says you have to notify the sexual offender, and it doesn't really prescribe how to do it. Here, it prescribes very explicitly that it has to be done via first-class mail. Do we need to, as you've done in other places in the building, need to spell out that in the homeless situation, here's how we're going to provide notice?
Well, I'm going to have to call on my sheriff about that thing, but I think what you're going to find is this was an effort to prevent them from having to track down and stick everything in somebody's hand. Puts it more on the burden of let's let the postman deliver it to them. Terry, you got a comment?
Well, I think my opinion would be, and that question has not come up, but it's a good question. My opinion is, or my thought is, you're saying if there is no mailing address, how do they get the notice to them? And I think under those conditions, I don't think there's any sheriff in the state would object to that notice being sent to the sheriff's office. That person is being told he has to or she has to report, and that notice would be hand-delivered at that particular moment. And I actually think that's a little bit of a check and balance, that we know we have yet another notice that someone should be registered.
And if you notice in the statute, what we've done is we have given that notice to the sheriff, which is was not there before.
I just don't want to create an issue where an offender can argue that I
Sure.
because I live in a parked car, I can't receive that notice just by the nature of it.
All right.
Why couldn't we make it
Hold on just a second. Terry, your association keeps on getting brought up. You want to have a seat at the table just in, I know you're not signed up, but just in case it's brought up again, where you could respond for the Sheriff Association.
And we've got, who else is back
got
there?
a few
We've
more
got all
questions
kind of folks who are helping support this bill.
I have nothing for it. Just food for thought.
Okay.
Mr. Chairman, may I just add something on that particular
Please.
note? If you'll notice the current statute, one of the problems is there is no notice to the offender, really. This is an effort to get notice to the offender, to the sheriffs, to the appropriate entities. I'm like Terry, I just don't think the question had come up on notification to the homeless. We were trying to get notice out there in the first instance. And
My concern is by explicitly saying, here's how you have to give notice of this risk assessment, are we by fixing one problem, are we creating another one?
I don't think you want to make it too tight. I say I don't think you want to make it too tight. We make it too tight that you absolutely have to do this. In other words, if we've done what this statute has, we've tried in good faith to give the person notice. And if we figure out some way that we have to have personal service or something like that, that would be the basis of a lawsuit if we didn't do that. Okay.
Representative Franklin.
Thank you, Mr. Chairman. Looking back on in Section 2, starting with lines 43, where we say the sentencing court shall determine the likelihood that a sexual offender shall engage in another crime, and so forth. Now, I've always been under the impression that we punish an offense that has taken place, rather than getting into the futuristic thing where the little ball comes out of the machine that that indicates that you're about to commit an offense, and therefore we're going to punish you for an offense that you're going to commit in the future. And it seems like what you're kind of stepping back from the emotion of the heinousness of this type of offense, which, as Chairman Golick knows, I would like to actually see us mete out the death penalty for child molestation. I think that is the appropriate punishment for a child molester. But it seems like what we're doing, instead of just punishing the offense committed and tried and convicted of, we're punishing the potential to commit a future offense. And if you could address that, please.
Well, first of all, while I share your feelings about the death penalty for these type people, that's not the law. And the law is that we cannot give the death penalty unless we have a homicide. I mean, that's the Supreme Court law of the land.
Well, we make the law. They don't make the law.
Well, okay. I'll let you take it to the Supreme Court and tell them that.
Louisiana did, and they got overturned. So.
Yeah,
let them try to stop an execution when we are actually flipping the switch. But
they do it all the time.
No. They issue an order, whether it's legitimate or not, and the prisons comply with it out of their choice.
Okay. I recall the famous Cherokee Indian land grab, or whatever you want to call it, when Georgia was litigating with the Cherokee Nation back in the 19th century. And I remember President Andrew Jackson said, okay, Supreme Court, you got that. You've entered that ruling, now enforce it. Well, unfortunately, since Andrew Jackson has done that, there's been a tremendous amount of law that says, simply put, that it is the law of the land. Their interpretation of constitutional rights are there. And in a long series of cases, the bottom line is we cannot impose the death penalty on someone unless there's a homicide. With that said, I don't disagree with you. I think it's a horrible crime. I think it's a monstrous crime. And I think these people that do this kind of thing, I wish there was some way to do that. Mm-hmm. But I'm also a realist in the sense that I know that I cannot, I can't represent to you or anybody else that if we did that, it would be successful. It would not be successful because of the law of the land. Mary Beth, you want to add 2 cents on that?
let me just Not on that part, no. I litigate in that court a lot. If the one thing to point out in Section 2, the risk assessments, that's already there. I mean, that's being done. The risk assessment profiles, those are in the code. A lot of this information that's talking about what the trial court should consider, it's already over in the section now talking about what the Sex Offender Registration Review Board considers. If you're looking at 42.114, has some of this information in it. So that's there. And just for a clarification, if you look at current 42-1-12, there are some provisions on level 1, level 2, and predators. What's not specified much is the delineation on how you treat level 1 and level 2s in the code section.
I hope I've answered your question. I'll be glad to expound more if I could. If there's anything else you'd like to ask, but
it was mainly that that the idea of punishing the potential to commit a future offense.
These folks, like it or not, they're so dangerous that even with the criminal justice system that we have and the sentences that we impose, particularly the dangerous predator, somewhere down the road they may get out. And what we're trying to do is, to the extent that science will allow us, identify their probability of doing it again, and exacting the most thorough and far-reaching punishment that we possibly can on these folks that have that potentiality for predation, that are dangerous predators in the future. We want them isolated. We want them identified. We want everything, whenever possible, we want everybody in the community to know who they are, so that we can make certain that our society and our state ostracizes these people to the maximum extent that the law allows us. But with saying that, we still have to stay within the bounds of what the law of the land is, and that's one of the reasons we're doing what we're doing, is to make sure we in fact do that. I hope I've answered your question.
Back to Representative Knox.
On this issue, just backing up a little, with respect to that punishment issue that Representative Franklin raises, I think it's a legitimate issue. But I want to ask you, isn't it correct? Am I correct in recalling that civil confinement statutes in some states have been found, with regard to predators, have been found to be constitutional? That is, where even though they've served the maximum sentence for the offense, that they can still be confined in an institution under a civil confinement. I guess it's an order of the court or finding in the court, and that those have been tried, I think, more than once in several states. And
I can't recall what state. Kansas
I know
comes to mind.
they're
Sure
western
that's
states,
right.
I think, where that they've been done. Maybe Colorado or.
I mean, there are
No.
court decisions clearly making the registration requirements and ruling that those are not punishment. That's a remedial, not a punishment measure. And I think you're right. And I don't remember what the state is about the civil commitment.
Apparently, there's still some issues about that. But let me ask you about. Thank you. Let me ask you about on the issue of this notice to the homeless or whoever it is. Almost all of these folks are going to be on probation or parole, and it seems to me that we should consider having the notice made to the probation officer or parole office where the person would supposed to be supervised or should be supervised according to whatever the Department of Corrections record is, and that would constitute sufficient notice on them if they're not otherwise served, because they're supposed to be showing up there to report every 30 days or so often, and the probation officer gets that, and they call them and they don't find them. There's a problem anyhow. So it seems to me like that would be. Is that in there already and I missed it?
Well, you already have the Department of Corrections. You have the Department of Corrections who's doing this. You have the sheriff that's under the statute. We are including now the sheriffs.
You just want to include them in addition to the others? Okay.
Yeah. Under the old law, under the present law, it's only the Department of Corrections. We're adding the sheriffs so that sheriffs know these people, where they are and what they're doing.
Representative Abrams.
And just to that point, I I would caution against putting mandatory notice requirements in the hands of private agents, even if they're acting on behalf of the government. By sending it to probation officers, I would be concerned, particularly given some other legislation that's moving through. I think since this is supposed to stand in place of, since this is a governmental obligation, I think sending it to the sheriff's office, where they have to check in anyway, there's a way to create a certification system where if they come to the sheriff's office, they can then receive it from the sheriff. I wouldn't put it in the hands of parole or probation officers. I would just be concerned about that personnel having that obligation.
Mr. Chairman, may I follow
Yes,
up on
ma'am,
that
please.
one point, please? The purpose.
Hold on just a second. I think Mary Beth's going to try to answer that.
Well, but the purpose of this notification provision is to deal with the fact that we don't have a time limit for filing an appeal, so that there is some date from which that time runs, so that we can say we've got a notice date, the appeal runs. Now, as in with any other case, if I don't get notice, then I go to the court and say I need more time because I got to get notice. I need another 30 days to perfect my appeal. That was the purpose of putting this in at this point.
So, to follow up on Representative Ramsey's point, if receipt of notice, if it goes to the sheriff's office, if the sheriff just and if there's also the requirement that the homeless check in at the sheriff's office, is there an impediment to having them just as a matter of course if the person agrees that the sheriff's office will be their place of receipt, then you have, number one, you have notice, you have someone who can receive it who's a stable recipient, and you have the ability to control proof of notification, because if you have to check in, you've got a sign to receive your certification, and you keep it in the same space instead of trying to create multiple points of contact to deliver your notice.
I think my good friend Mr. Norris from Sheriff's has to comment.
That was the exact comment I had. I don't personally see the difference between a state agent as a parole or probation officer and the sheriff giving that notice, as long as somebody did it. In many cases, in most cases, I think, other than some probation cases, I think what we're going to see is the sheriff is always going to be that first contact. And I don't have an objection to the sheriff doing that, and I don't think they would either. Maybe your point is that you want a single point versus several points, and that's a point well taken. I mean, we wouldn't have a problem with that.
Well, I think we're just trying to get at,
yes, sir,
not just that they got notice, but or that the notice can be delivered to them, but that the service on these entities that they're supposed to be reporting to would constitute delivery of the notice. That's, once y'all got it, they're supposed to be showing up there. If they don't show up there, it's on them. So we shouldn't impose on ourselves a requirement. We go chasing around trying to find these folks.
That's exactly my point.
Yeah.
That's exactly my point. We don't want to impose that standard.
May I, Mr. Chairman?
Sure.
This particular notice is just for the appeal purposes. We're going to be notified. Corrections is going to advise GCIC when that person is being released from prison, and GCIC will give us that, and the person himself or herself will also have an obligation and is told before they leave the institution, you've got 72 hours now, and since you've been released, to go see the sheriff where you're living. So there's some safeguards built in to that notification.
Chairman Golick.
Thank you, Mr. Chairman. The Senator Harp, just a very quick question. Section 8 on page 6, and you may have gotten into this when I stepped out. Just clarify for the committee what Section 8 does on page 6.
I'm sorry, what was your question?
It's Section 8 on page
Right, I have
6.
it, yeah.
If you could just clarify as to what the effect of that section is.
Did you
What?
get me?
I think that's
Terry?
maybe Terry.
I don't know.
I mean,
I had a question mark. Sorry, Mr. Chairman.
I can tell you what I think it does. This is not.
I assume it goes to the issue of removal from the registry.
That's my. And again, this is not something I had a part in. But what currently you have to wait the 10 years before you seek removal from the registry. I believe this language would say once you've completed the sentence, you can seek to be removed from the registry. I think That's my understanding of what that change is.
Well, completed his or including any period of parole or probation.
Probation, right. And not have to wait any, not have
The
a waiting
additional
period.
10 years beyond that,
Right.
and the ability for a person on the registry, and of course the situation that I'm thinking of is what we're euphemistically calling the Romeo and Juliet situation of those people who committed what we now consider to be a misdemeanor, consensual teenagers at the time, the 3-year difference. My assumption is that the ability to petition to be removed after the sentence, including parole or probation, but not having to go that extra 10 years is the contemplation of the previous law, that process would be exclusively in the hands of the Superior Court. And my sub-question on that is, I just want you to confirm that would be the Superior Court. Would that be with any Superior Court or with the sentencing judge on that particular matter?
I believe the statute currently provides for petitioning well, it says the court, but it's the Superior Court, I believe, dealing with where the conviction came from is the one that's going to be dealing with
So it'll be
it.
the sentencing judge?
Yes.
Okay, thank you very much.
Of course, it may not be the actual judge. It would be that office.
This could be the last question, Representative Collins.
Okay. One last question, and we went, and this is one of the problems of having to do this like we are, but I appreciate the answer so far. Explain, and if there is no connection, just say there's no connection. But explain in this large conversation we've had concerning notification of what's in the sex offender industry or how they've been classified. Explain how Section 12 and Section 2 relate.
Okay.
Because just looking at it, and again, without seeing the whole thing, Section 2 deals with the sentencing, which we're looking at, and I appreciate Senator Harp's just saying it's like a pre-sentencing hearing in the federal court, but actually it's enhanced sentencing here that we're looking at. They're going to know what their assessment is before. So how does 12 and 2 relate, and how do we get it just doesn't, it seemed to be addressing two different things here.
If I may. There are two different things.
Okay.
That's why it seems that way. What you've got is the current process where the board is making the classifications. Because of the Section 2 would shift that from the board to the sentencing court and effectively make it part of the sentence.
Right.
You can't do that for people who've already been convicted and sentenced. It's still got to be done by the board. So you've got a long-running time period where the board's going to be making determinations. You've also got people moving in from out of state that need to be classified by the board. Section 12 is an effort to deal with any classification made by the board, and deal with the appeals from the board's classification. Section 2 deals with if you move this back to the trial court prospectively. That's what Section 2 is dealing with.
Okay, so from here on, basically, in essence, this bill passes at a date to be certain, whenever it starts. Section 2 will deal with everything after that. Section 12 is trying to address the issues of what's already in the pipeline. Is that the best way to describe it? Thank you.
Somebody that's coming from another
Or coming from another state. All right, thank you.
Yes.
Well, that rounds up all the questions. Appreciate your time of answering all those. We have one speaker. Senator Hart, do you have something?
No, when do we need to be back with y'all?
My sense is that we have one more witness on this bill. I don't know that we're going to go in at 10 o'clock. My sense is that if we don't continue that today, we would do it on Monday morning. Chances are we're not going to meet tomorrow, under the assumption that we're going to go in at 9.
We're not meeting tomorrow.
Correct. Well, I mean, our committee.
Oh, okay. I think
tomorrow, under the assumption that we go in at 9 o'clock.
I was hoping you were going to let me go home.
And Friday. Well, we have one more witness. My sense is we'll probably go ahead, Mr. Chairman, given the time. I know people want to get to the floor for roll call. That we'll continue it on Monday morning, first thing, amongst other business, but it'll be the first one up. That additional witness. Okay. Then we'll go ahead and close off testimony. And my sense is that we'll have a begin the process of formulating.
Could we know the nature of what the witness is going to testify to, so if we need to respond to it?
Mr. Bearden has that right.
It's Jerry Weber, the Southern Center Human Rights.
I was largely going to support the bill and say essentially that it's resolved resolved or largely resolved 8 different cases that are pending or decided.
Well, that's the most efficient testimony we've had in weeks. Thank you.
That being the case,
I think what we'll go ahead and do is, now that we're dispensed with testimony, we'll begin the process of formulating a substitute. Again, I think just as we're doing with Senate Bill 42, the public defender indigent defense public defender bill.
Sure.
We'll circulate that to the committee prior to taking it up in the context of markup, and then we'll march on from there.
Okay. Let's just make sure
And to the author, of course.
Sure. Let's just make sure the skunk that we've turned into a nice little kitty cat doesn't die because we sure need some relief out there.
Well, we'll, as always, Senator, we'll agree, we'll disagree, then we'll agree to disagree, but the process will move forward, and
Thank you.
That's from where we sit, and I'm sure
I
it's from
understand.
where you sit as well.
I do too.
Okay.
Thank you.
You so much.
Thank you all for your help.